Okay, let's go ahead and deal with the matters in this case that we have set for today. It was a little unclear looking at the clerk's record. What exactly is set for today? What are the motions that are set for today?
Your Honor, I think it's the plaintiff's motion to sever and then the defendant's motion to dissolve the temporary injunction and the motion to unseal court records.
Okay. All righty. Let's proceed.
Which motion would you like to hear first, Your Honor?
Whichever was set first.
I believe that is the defendant's motions.
Okay, let's go ahead and proceed. Any argument by defendant?
Again, to severing the motion. Your Honor, the only standing issue right now is the plaintiff's accusations of me recording my daughter and plaintiff's conversation. Severing it into another case only creates another case. It doesn't solve anything. It doesn't help anything. It just makes two cases out of one. And we're heading straight into the motion for summary judgment hearing on this motion. If there were several claims pending in this case, okay, but with just one, it just doesn't make sense. In the beginning of February, this case, I believe.
You still talking, Mr. Builder? I can't hear you.
Can you hear me better now? I'm sorry.
Yes, go ahead.
I don't believe that severing this issue is going to create anything but undue delays, because the plaintiff's complains that about me recording his conversation with my 8-year-old daughter is the only standing issue in this case. So separating it and creating two lawsuits out of one is not going to help anything. It's just going to cause undue delays and is going to complicate everything. And we're heading straight into the motion for summary judgment on the only remaining cause of action.
Response?
I guess we're taking the motion to sever first. Yeah, Your Honor, Rule 41 provides broad discretion for the court to sever claims. Contrary to Mr. Builder's contentions, this will actually increase efficiency. We're working towards finality here, like a final judgment. The majority of claims in this matter, while we wait to try the last remaining cause of action.
So I guess we're hearing, I'm a little unclear what we're arguing right now. The motion to sever right now, or what are we arguing right now?
I guess we're arguing the motion to sever. I thought the defendant was going to present his motions, but the plaintiff filed a motion to sever. And simply put, we're just trying to work towards finality here and get a final judgment.
Do we have, I'm a little unclear, you talked about a summary judgment that's pending, is that right?
There's not been a hearing set. There was one, and then the defendant took that down, Your Honor, he did seek leave to amend his answer. The answer hasn't been amended, and there's been no new setting for the summary judgment, to my knowledge.
I'm going to wait until after the summary judgment to rule on the motion to sever. If I go ahead and dismiss the entire case, then there's no need to sever. If I don't dismiss the entire case, then I would probably sever it.
Okay. Can I reset the sever for the summary judgment date?
What'd you say?
Can I reset the motion to sever for the summary judgment date?
That's a good idea.
Okay. Thank you.
Next, the motion to dissolve.
Yes, Your Honor. There are two motions. They are somewhat connected. Motions to dissolve temporary injunctions and motion to unseal the case. I'm filing those motions, and I'm asking you to do that because plaintiff keeps making threats on continuing litigating same issues that are pending in this case in other courts. And this case is technically sealed. I'm asking you to unseal records because first, it would harmonize it with what is going on in fact. This case is searchable on a plethora of online platforms. You can go online, you can go to websites like docketalarm.com, which shows you pending cases, issues, motions, and they're using open source tools and open records. to reach out to those cases. And that case is there with all its motions, pleadings, evidence, and everything. So unsealing those records would simply accept the factual state of the facts right
Are you
now.
actually, so let me make sure I understand. Let me make sure I understand your argument. Are you asking to unseal this case or the other case?
This case, this is the only one.
Okay. Response?
Yeah, Your Honor, there's been no basis in his motion for this. There's nothing in his copied and pasted motion that supports the unsealing of this. There's no record he specifically identifies that he needs unsealed. There's only 3 records to my knowledge that have been sealed, and that's the first, second amended petition in this case. So he's not presented from filing pleadings in his other case. He's not presented from using them. There's nothing in this motion to support the unsealing.
That may I answer?
Sure.
That's not entirely true. The problem is this, there are 2 problems, in fact. First, the only standing issue in this case, which is plaintiff's claims about his conversation with my 8-year-old daughter being recorded, is word to word the same claim that the plaintiff and his wife filed against me in Collin County. If I'm defending one here successfully, I'm going to take it to the Collin County, and I need to be able to quote this case and refer to this case. Every time I do that, plaintiff, Mr. Zidrick, who is financing both, and his attorneys in Collin County, vigorously protesting it and threatening all sorts of sanctions against me because this case is sealed and I cannot mention it anywhere. Secondly, Mr. Zidrick openly threatens to file another lawsuit with a cause of action and with complaints he tried to raise in this case about some website that talks about him. This is the violation of temporary injunction that Mr. Zidrick was trying to set for hearing, I think 5 times already, but every time he was taken down the hearing 24 hours before the hearing was actually scheduled. Now he wants to file it as a separate case, and he emphasizes that I cannot talk about this case if the other case is open. I'm sorry, Your Honor, this is nothing but legal harassment with Mr. Zidrick, and I want to be able to openly discuss it with anyone. And I want to be able to write and publish about this.
So let me make it clear. The motion to seal doesn't keep you from talking about this case. It just, there's what, Mr. Herrera, there's certain documents have been sealed in this case, but not the entire file.
That's exactly correct, Your Honor. There's nothing in this order that prevents him from talking about it. There's, I think, 3 documents. There's all of the plaintiff's petitions that were sealed.
So if I can discuss about this case.
Yeah, I'm going to deny them. I'm deny the motion.
Okay.
And then the motion to dissolve temporary injunction.
Apparently, motion for the temporary injunctions are used by the opposing party simply to harass. Mr. Zidrick claims in his temporary injunctions that he's scared of me and that I can do some harm to him. However, in the past year, it was Mr. Zidrick who was constantly trying to do harm on me and accusing me of violating those injunctions. Mr. Zidrick on a regular basis jumped out of his car shouting profanities during the child exchange. And then he runs to this court accusing me of violating those temporary injunctions, but never set me for hearing again. Not like a month and a half ago, Mr. Zidrick.
When was this temporary injunction entered?
June 24th of last year, Your Honor, or I guess 2019.
2019, okay.
Yeah, it was at the very beginning of the case, and I wasn't unable to attend the hearing.
Okay, and this is the temporary injunction we're talking about?
I believe that's correct, Your Honor.
Okay. So what's currently prohibited is that defendant builder not come to the plaintiff's work and that publishing, dependent builder be published from publishing, submitting, or distributing in person any written or verbal statements pertaining to plaintiff. Okay, so that's what we're talking about. All right. So your concern is that he's being abusive and violent at these particular exchanges. Is that your concern, Mr. Builder?
And then running to this court to accuse me of this. I mean, Your Honor, we're talking about a person, Mr. Zedrick, who wrote me and in writing, like a year or so ago, offered to settle the legal dispute over a boxing match. And if you think I'm joking, I can share the screen and show it to you. And Mr. Zedrick and his wife, I am taking my child to a soccer game. Then Mr. Zedrick and his wife show up at the game, come to me closer than 50 feet, and then run to the court accusing me that I got closer than necessary to them, and I have to be put in jail for that. Mr. Zedrick is chasing me through my car.
Response?
It's insanity.
Well, he's describing himself, actually, Your Honor, and the law is clear that it's his burden to show that there's been new evidence of changed conditions or fundamental error in granting this injunction. He hasn't shown a shred of evidence. He's just spouting off. There's nothing to support his contentions here. He has to show that the status quo has changed that makes the injunction unnecessary. And contrary to his contentions, he's the one who's violated it. He's come within 50 feet of my client. We believe he's put up another website about my client that has defamatory information. He hasn't met his burden to dissolve this injunction, Your Honor.
So let me just say this, Mr. Builder. It sounds like your real complaint is that they keep threatening you with a violation of that keep threatening you that they're going to file contempt charges related to this temporary injunction. That's not really a basis to dissolve it. And I think your other complaint is that they're doing the same thing to you that they're complaining about in this temporary injunction. If that's the case, then you should probably file it. If that's really the case, then you should probably file a TRO against them if you haven't already, to make these prohibitions mutual, which seems perfectly reasonable to me. But I don't think it's appropriate to dissolve this at this point. So I'm going to deny the motion to dissolve as well. What else do we have set for today?
Your Honor, if I may, Mr. Rama is not correct about the evidence.
So Mr. Builder, what else do we have set for today?
That's pretty much it.
Okay, great, guys. I'll go ahead and sign the orders and just go ahead and get whatever else that you need. And we'll see you guys soon. Be safe out there, okay?
Thanks, Your Honor. I have one quick question before I go. It's okay.
Sure.
I think we have some summary judgment orders that weren't signed from October 16th. I just want to follow up on that. I think we were granted.
Sure. Let me see what there's been so much briefing in this case. So can you see on the system what?
Yes, it's October 16th, I believe.
Is the date the order to strike?
Give the order granting the plaintiffs no evidence motion for summary judgment.
Is that on the 15th? Or is it this one here?
I think it's that one right there.
Okay, so I need to sign this?
I believe so. Yes, I was granted, Your Honor.
It was granted? This says denied. Oh. The plaintiff was granted and the defendant was denied. Is that right?
Correct.
And my order for leave, if you don't mind.
Okay, let's see.
Was granted 2 weeks ago.
Okay, let me take a look. Tell me is there any other orders I need to sign?
I think that's it.
What date was the leave filed?
It was
or the order filed?
January the 4th.
The leave occurred December 28th.
December 28th, yes, around that time.
Okay. Is it on the sanctions? Which order? Can you see on the screen which order are you talking about?
I believe it's proposed
Here?
order leave.
There we go. Let's see. Is that correct? Is Mr. Herrera, does this order need to be signed as well?
Yes, Your Honor.
All righty. Any other orders that I haven't signed? There's been so many hearings in this case.
I think that's everything.
All right, guys, thank you so much, and I'll be right back.
Thank you.
Thank you.
You guys are excused.
Thank you. Have a good day.
Yep.
Okay, everyone, is everyone here?
I see Don Godwin's name, but I don't see Don.
And I'm Alan Lowenson here, Your Honor.
Godwin, are you there? Godwin, are you there?
Yes.
Mr. Godwin, are you there? Mr. Godwin, are you there? Miss Scott, are you with Mr. Godwin's office?
I am, Your Honor. He's coming.
Okay. All right, well, while we're waiting, I'm gonna go, I'll be right back.
Morning, Seymour.
Hey, Don.
How are you doing?
All right, thank you.
Hey, Alan.
Good morning, Don. Happy New Year.
Happy New Year to you. Hope you're doing well.
Thank you.
Hello, Judge.
Morning, everyone.
Judge, are you rested up?
I am ready for justice.
Ready for justice?
Bring it on.
Oh, my God.
So as I understand, all we have set today is an agreed motion to allow additional pages for the briefing in this case. Is that right?
So the summary judgment motion, the summary judgment brief, and the summary judgment appendix, as well as the responses by Gail.
Let me just kind of say this. I know that there was an order issued by the judges. I signed it at the beginning of the pandemic. I never enforced that order. So if you want to just do an order that says that that you have permanent leave to concerning that order to file what you need to, I'm not going to ever enforce it. So,
I would appreciate that, Your Honor, because we may be filing a motion for summary judgment. Don't want to have to go back to this drill. So that would be great if we could do that.
yeah.
Are
if
you
guys-
are you saying, Judge, just for clarification, that you would accept an order essentially saying that we have we can those page limitations do not apply to any pleadings in this litigation, or just the summary
Correct.
judgment?
I'm not ever going to enforce that. So
I think it only applied to summary judgments anyway, but I could be wrong.
I don't think that's correct, but
Oh, okay.
but I'm just trying to make it easier for you guys. I feel bad kind of even ever agreeing to that because it was the beginning of the pandemic and we just weren't sure what was going to happen, and we weren't sure about Zoom. We weren't sure about a lot of things. And so I feel bad that we're even wasting time on this. I don't think it's that order is necessary. It's not needed necessarily in vast majority of cases. I guess it's useful if a case and sort of someone's being really abusive, I guess, but I can't imagine any of the attorneys in this case would do anything abusive and deliberately file motions that are not necessary or excessive. So if you want to draft an order and you guys all agree to it, that order is not going to apply to any of the pleadings in this case, I'd be fine with that. But if you don't want to, you don't have to. I just hate to have you spend this kind of time and effort to do this.
Well, Judge, we've already drafted an agreed order. I think Mr. Godwin and I will be able to tack on another provision and just add the language that you've just suggested, and we'll get that to you shortly.
Okay, I'll go ahead and sign the one you submitted, and if you want to do a new one, that's okay too. But
Okay,
But
then I'll
Judge,
tell you what, we'll
Judge,
leave
I'll
the one.
certainly- Go ahead, Seymour. I apologize.
We'll leave the one in place with you. You can sign that, and then Mr. Godwin and I will come up with another order, and as well as for Mr. Lowenson, and then we will submit that as well.
and it's just make sure you submit it as an agreed order. That would make it
Yeah.
easier and it would get to me quicker. When is our trial setting on this case?
Well, it's supposed to be set in June of this year, and that leads me to tell you that Mr. Godwin and I, you had previously said you didn't think we were going to get set. So Mr. Godwin and I are now
Get set or
negotiating,
get reached?
get reached.
Okay, yeah.
Right. And Mr. Godwin and I are now negotiating a new scheduling order. I think we picked a trial date and circulated it to my folks, I think in April of next year. So, and we should be submitting that as well in due course.
Okay, I'm super flexible. I mean, as you know, we haven't had a jury trial in 9 months. The judges are kind of discussing what to do about remote trials. I don't think this case would probably be useful for that unless the parties all agreed, which I can't imagine they would. And so we're just going to be, I guess it's conceivably possible with the vaccine that we could start up jury trials in June, but I just think that's extremely unlikely. And so if you guys prefer next year, I think that's probably wise. I'm not going to order it, but I think that's probably wise. And if you guys are agreed, I'm glad to move it.
I think we are, Judge.
We're working on a judge, and I've talked to Seymour about it, and we both saw in our judgment how we thought it was unrealistic to try to do it this year in view of the pandemic and where we are in the discovery, et cetera. So Seymour and I'll come up with something that we'll submit to your honor and Alan and make sure we're all in agreement on it. Now, just on a little bit of a light side, Judge, I certainly understand that, what you're saying about, an order that would allow for unlimited pages, but you gotta remember with these tired eyes of mine that Seymour writes, he'll write a motion and it'll be damn near like an encyclopedia.
Don, you don't have to read past page 25 if you don't want to. You can impose your own limits.
And Judge, as tired as Mr. Godwin's eyes are, he's got a lot of young eyes in his firm. You've got a pair right there with Morgan Scott. So he's got lots of help. He's got more eyes than I do, and I've got 4 of them. So
she can read. They can just read it to you, Don.
Seymour, I can't ever get one in on you. You always come back.
I tell you what, Don, I'll put it on an audio and then you can
Oh
listen.
my
to
God.
We could do better than that, Seymour. Why don't you start a podcast?
Yeah.
But have Don as the only subscriber.
And you could just read all of your motions.
Right.
Oh,
Maybe not as, it won't be quite as popular as Moms with Murder or Moms and Murder or whatever it is, but it will still be a big hit, I'm sure. That's hilarious. That's hilarious. Well, I'm so glad you guys had a good holidays, it sounds like, and it's great to see everybody. And I'm happy to try to accommodate you guys however we can and making sure you get your case to resolution. And if you guys want to move it to April, I have no problem with that. So we just want to try to make this as convenient as possible for everybody. So you guys have a happy rest of your week. Be safe and the vaccine is coming. So we just need to keep being safe.
I'm signed up already.
I got my first dose, Your Honor.
You did?
I did.
Wait, are you, I won't even ask, but I didn't think, you're too young.
I am over the young age of 65.
Oh my gosh. Wow.
Alan, did you get the shot?
I got the first dose. It's in
Well,
the arm.
I tried yesterday to get it over at UT Southwest and they put me on a list, but I don't have it done yet. I mean,
I won't bore you with my efforts, but I spent 3 hours one night Googling and getting a spreadsheet of all kinds of places and spent 2 hours the next morning calling everyone. And I found a mobile site in Grand Prairie at a shopping center.
Oh my gosh.
And went there for 5 hours and finally got it at the end. And I left and a friend of mine showed up and I said, "Did you get it?" He said, "No, they shut it down." And I said, "Why?" So they had one doctor going from car to car and most people were there 5, 6, 7 hours. And apparently some guy got out of his car and went up and clocked the doctor.
boy.
And
Oh my gosh.
and they shut the whole thing down for the day. So I was barely in and out.
Boy.
Wow. That is
Seymour, you had
not.
it yet?
No,
What?
but in Tarrant County, I live in Tarrant County. I've signed up and I'm supposed to get, notice in a couple of weeks.
Well, I'm working on trying to get it done, but anyway, thank you, Your Honor, for. your
Thank you,
time.
Judge.
Yeah,
Alan,
you guys.
more good
Wow,
to see
that's a
you
great
guys.
story about.
Crazy.
It's crazy times. I'll just say
It
that.
is.
It's crazy times. All right. Well, it's great to see you guys. You guys be safe.
Thanks,
All right,
Judge.
thanks,
Take
Your
care.
Honor.
Bye-bye.
Bye-bye.
You're still on YouTube.